If you're an attorney that's planning to leave big law to start your own boutique firm, one of the first questions you're probably asking yourself is, how does legal malpractice actually work? Over the last 5 years, malpractice claims have shifted due to remote work, higher client expectations, and more complex legal matters. Today, I'm going to break down how malpractice works, what it covers, and what attorneys often misunderstand about it. Legal malpractice insurance, or professional liability, or also known as errors and omissions, is designed to protect attorneys for when a client alleges a mistake that was made in the delivery of the legal services that they are paying for. At its core, the policy covers allegations of negligence, errors and omissions in legal work, claims arising out of your professional judgment. Important to know that coverage is triggered by an allegation, not an actual mistake. And this matters because your defense cost is triggered when that allegation is formally brought up against you, even if the claim is later found to be fraudulent and is dismissed. Over the past 5 years, insurance companies have reported very similar drivers of claims being reported. These covered claims often include things like missed deadlines or statutes of limitations, drafting or documentation errors, conflicts of interest, failure to properly warn or advise a client, inadequate supervision of your associates or your staff. Many of these claims are not about poor legal strategy, they're about process failures, calendaring systems, communication gaps, or unclear engagement terms. One of the most valuable parts of your malpractice coverage is your defense cost. Most policies will pay for attorney defense costs, court fees and litigation expenses, and expert witnesses when required. However, it's important that you know that whether your defense costs erode your limits is determined on how the policy was written when you purchased it. This is a detail that a lot of attorneys miss when they're comparing coverage, especially the new attorneys that are moving from big law to boutique and starting their own firm, because you just don't know any better. So who's covered under a malpractice policy? A typical malpractice policy covers the named firm, partners, members, and shareholders, associates and of counsels, legal staff acting under your supervision. Coverage also only applies if it falls into the scope of the legal work that is defined within the policy terms. Having legal malpractice insurance is not required in the state of Florida, but it is a financial safety net for your firm. Understanding what your policy covers is critical to the success of your boutique firm. At The Bunker, we love to help big law attorneys that are starting their own firms. Click the link below to schedule some time so we can help you get set up right.